Hello everyone. Welcome to CALS Chai Chats, a podcast on Asian law. We've traveled a fair bit with this podcast series, Mario, and this is our 10th episode. And we are, of course, very honored to have with us Justice Aidan Xu, back in Singapore, so closer to home for this 10th episode of our podcast. Welcome, Justice Aidan. And it's a pleasure to have you with us today.
Well, thank you for having me. It is indeed a great honor and a great pleasure to be here. Thank you.
So I thought we'll start this conversation by asking you about two themes that you've spoken about, inclusivity and access to justice. I'm wondering if you can speak a little bit about the relevance of these two themes and how they sort of factor into a rule of law society in Singapore.
Right. Thank you. So we have been emphasizing in Singapore, not just in the judiciary, but in the whole of the state, the whole of government, about the importance of the rule of law, how essential it is for our continued growth, our continued existence as a country. It really is one of the qualities that distinguishes us from our many other jurisdictions, and it's something that we want to continue to emphasize. Now, what is important about the rule of law is not just that we ensure that there's impartiality, that there's no arbitrariness in the outcomes of legal proceedings and how laws are implemented, but also, importantly, that there is a real and practical impact for the ordinary citizen or ordinary court user. It is important that we ensure that all those who have to be involved in court proceedings feel that they have access to the system, that they can participate in the proceedings. There's no point having a system that in theory abides by the rule of law if the people affected by it are not able to come to court, not able to participate fully, not able to understand what is happening. So that becomes a core essential part of what we think we need to do as the courts in Singapore. And it's been emphasized by the Chief Justice, particularly last year, in a couple of his speeches in the Conversations with the Community series, in which he has really laid out that it is an important systemic function of the courts to facilitate access to justice.
Right.
So we really need to bring that in.
Mm-hmm. That's interesting, Justice Aidan. So what are some of the key initiatives that the judiciary has pursued to ensure, as you said, participation, inclusivity, and so on?
I think what I like to emphasize from the start is that we try to tackle these issues in a multi-layered, multi-channel way. And while we have highlighted some of our technology initiatives relating to access to justice, I must emphasize that it's never about deploying technology just for technology's sake.
Right.
It's always about identifying what the issue or problem is and working out from there what the appropriate solution might be. So, leaving aside for the moment our technology responses, if we look at some of the things we've done, they've been actually either zero or no technology kind of changes. We have an access to justice division. It was originally an office, now it's been expanded to a division. And that reflects the importance placed on promoting and facilitating access to justice for all court users. And the office and division now tries to ensure that there is active participation by court administrators and judges throughout all the three courts that we have in Singapore. So among the things they've done is to look at some of our processes and procedures, identifying things that might be more of an obstacle rather than an aid to people who need to interact with the system. So to take a amalgamation of examples, sometimes when we communicate as a court with our court users, aside from the normal legalese and that kind of thing, and perhaps being Singaporean, we tend to be a bit more careful, a bit more cautious in what we put in. We put in more just to make sure that we covered all the bases. And actually lawyers do that anyway. We have a tendency to put
That's right.
in a lot into whatever we send out. But if you're the recipient of some of these communications, you'll often be lost. I mean, even people with lots of academic qualifications may struggle when they see an official letter from the courts in dense prose, with lots and lots of text and requirements. It's not easy to navigate. So in various areas, we've been looking at trying to simplify our communications, perhaps emphasizing only one particular point at a time, and trying to see whether perhaps communicating in multiple letters might actually be better for everyone concerned and trying to cram everything together so that we address the issues as they come up rather than trying to anticipate everything at one go. So the other aspect of it, and this kind of plugs in not just to the work of the Access to Justice Division, but also to some of the early work that we've done. We have noticed fairly early on, a few years back, that some of the people who come to the courts were being sent from pillar to post. They've been being sent from the ground floor up to the other floor, trying to get their things sorted out at the appropriate counter. It's almost like one of those caricatures of a bureaucracy. And we started an early kind of effort to try to incorporate design thinking to improve what we were doing. And we realized that for some of our applications involving a lot of users who had to come on their own, self-represented persons, this was what they were encountering. They were being sent from one floor to another, from one counter to another. So as a result of that, some of my colleagues proposed the establishment of our service hub, which you see on the ground floor now. So for bankruptcy applications in particular, people can come in, they meet one person at the counter who try to channel them in the best way possible. There are printers and PowerPoints available, plug points available so that they can actually get their documents printed if need be and that sort of thing. And there are other booths for them to speak to the appropriate officers as required. So they're not sent from place to place, but as far as possible, we try to bring everything together so they don't have additional stress or trying to deal with too many things. So that's yet another illustration. But sometimes we think technology can provide a good answer, and that underlies what we're trying to do in the Small Claims Tribunal in our joint project with Harvey AI, which we've mentioned on other occasions. And basically, the main effort right now is try to see whether Gen AI can be beneficial to self-represented persons who have to go through our Small Claims Tribunal process.
Okay.
What I must emphasize is that no lawyers are allowed. It's meant to be a simplified, cheap process, so no lawyers are involved. And people who have issues about some kinds of leases or contracts will actually file on their own. They bring in their own evidence, load it up, and that sort of thing. And the defendants or respondents on the other side will similarly be able to present their case by bringing their evidence. The challenge these days is because there's so much ability to gather information, to record information, the amount of material that comes in has kind of multiplied, and you will have tons of WhatsApp messages, photographs, lots of documents, which is perfectly understandable, but everything is brought in. And it can be a challenge for the claimant to understand what the respondent is saying, and vice versa for the respondent to try and figure out what the claimant is actually saying. And also for the tribunal magistrate or judge to understand what the two sides are doing, and it's multiplied by 2 in his case. So we wanted to try to see whether Gen AI could help us summarize accurately and concisely. And we've had pretty good results from it. And we also want to make sure that the system that we develop at Harvey AI is well integrated with our current filing system. So we've married the two, and we hope to roll it out by November if everything goes smoothly. Technology projects being what they are, we hope for the best. But we hope that we can roll this out, and we think it will really benefit those who are involved in the small claims process by helping them understand each other's cases. And from there, hopefully we can narrow down the disputes and issues and make for smoother tribunal hearing when it actually comes up. Down the road, if everything works well from this, we can imagine technology coming in other ways. For example, even possibly, whether it's through Harvey AI or someone else, prompting the parties to consider, for example, resolution or settlement positions and that kind of thing. We're always keen on thinking of ways we can bring ADR or mediated settlements or that kind of thing into the process as well. So that might be further down the road, and I don't know just yet whether Gen AI can contribute in that. But that's how we try to think of the solutions to these problems involving access to justice. We look at a problem. Sometimes the solution might be in better communication. Sometimes it may be relooking at our processes, sending people from one country to another is not optimal. Sometimes it may be going to some of the procedures we lay down in our rules of court. And we want to be able to relook any of these as required. And sometimes the availability of technology may be a significant game changer, as with Harvey AI, as with translation.
Correct.
And even transcription. We have a lot of oral evidence in court, so transcription is a huge challenge for us. It's not something we entirely conquered, but we think we're on the way there.
So this is participation that is facilitated by technology.
So you want to make sure that people have access to the courtroom, that the door isn't stuck as they try to come in and to take part in it, and that they feel that they can come in, that they can actually understand what is happening, they can navigate the intricacies of the process, they understand what's expected of them, and then they understand what they need to do to get the outcome. And of course, along the way, we hope that we can encourage them to pursue alternative dispute resolution, to have a settled outcome rather than a kind of determined outcome by the judge, if possible, so we can divert them from the process. So I think the best analogy I have in mind is like when you go to a hospital, you know what the whole process is about. Although you have forms to fill up and something, it's about telling them that you need to see the doctor. You need to tell them what you think is wrong, what has bothered you, and you know that, all right, you may have to help provide some information about how everything could be paid for, that kind of thing. So you kind of understand. It's going to be a stressful, demanding kind of process, but you kind of understand where you are and you understand how you're supposed to respond to it. The problem, I think, for court processes, legal processes, is that sometimes it can come across as being entirely a mystery. People don't know where they are. They have a vague idea they've been sued or they need to sue someone, but beyond that, they're at sea.
It could be intimidating.
And it could be very intimidating.
For the regular person on the street.
Yes, and we know, you have the dignity of the court, you have to behave in a particular way, but it can be a huge, huge mystery for the users. They worry, of course, how do I address the judge? How do I behave? When do I stand up? When do I sit down? So we want to see what we can do to help them. So aside from all of this, and to help alleviate some of the concerns, we've got video guides, we've got pamphlets to help them understand how they're supposed to behave, how they're supposed to try to get through what they need to in the court.
This technology issue is very interesting, Justice Aidan, and we want to come back to that because I think for the benefit of our listeners, this is probably the most significant or novel aspect in this whole podcast that we're running. But going back to the issue of inclusivity, part of it is, of course, participation. Part of it is, in my opinion at least, transparency in judicial proceedings. There have been some efforts, for instance, lifting gag orders on the names of deceased victims in very serious offences. So these are, of course, some of the efforts. But what are the considerations in pursuing these efforts from a transparency perspective and in relation to the broader access to justice issue?
Right. So transparency, I think, is an essential part of rule of law because you need to ensure that people have faith in the justice system and they feel that there is non-arbitrary decision making.
Sure.
When you have unjustified or unwarranted secrecy, you will make people wonder whether the cases are being decided on other grounds, not about the law, but because someone is connected or someone's important and they're treated in a different way.
Right.
So having things heard in the open courtroom, having the names published, having the reports or judgments published, they're all essential components of ensuring that there is faith and trust in the system. And that, as emphasized by the Chief Justice and some of my other colleagues on various occasions, is really, really important because I think in this day and age, when there is less kind of visceral or habitual deference to authority, it's important for us to earn the trust of everyone in society, and being open and transparent is really a very important part of that. So for us, for example, we want to make sure that if anyone wants to observe court proceedings, they are able to do so by coming into the courtroom, which are generally open. And for us, even on occasion when we have hearings on Zoom with many claimants or interested parties, we try to put it out there to involve them, to let them participate by Zoom if, for example, they're overseas. There are, of course, exceptions when you need to maintain confidentiality. State secrecy may need to be maintained for sensitive cases. You may need to keep it for arbitration cases. But aside from these exceptional situations, by and large, court proceedings should be open for everyone to see, to understand who's involved, and that sort of thing. The cases you mentioned where the names of the deceased victims were published were not, however, to my mind, I was involved in a couple of them, really about transparency. As such, I made the orders to disclose the names of the victims because I didn't want them to be forgotten, to be known only by letter initials in a particular case. And I thought, to be frank, that was a bit dehumanizing when they've already gone through so much. So for those two cases I was involved in, I thought, yes, we needed to identify, give them the names that they had, and then, in a sense, to remember them, what we do. But of course, there have been other cases where the anonymization or redaction of names were perhaps not entirely appropriate. The requirements may have been stretched a little bit or not really properly considered by those involved, and the courts have taken measures in some of these cases to reverse some of the redaction and anonymization.
Very interesting.
So based on what you're saying, it sounds like the public is getting more engaged in the judicial process and so on. I'm wondering whether you can speak a little bit about the role of the court in terms of Singapore's constitutional structure. I know you've used the word systemic role in some of your lectures, and I believe the Chief Justice has also used that term. So would you mind speaking a little more broadly about the sort of role of the court in terms of the constitutional structure in Singapore?
Right. So, I mean, we're a Westminster jurisdiction, and we have an important role to decide disputes, including disputes between the citizen and the state. And we have an important role in interpreting the Constitution. We have developed I think, quite specific mode of working in which we give a lot of weight to the text of the Constitution, and we operate within, I think, the parameters of what we can see are the specific demands of the Singapore situation, given our makeup, our history, and our continued needs as a small state. But I think sometimes, perhaps because of social media or what people read there, so even some of our citizens, when they see these cases or when they try to understand what's happening, they may not be able to have a accurate picture of what the Singaporean judicial context, judicial practice is, because sometimes they may have inaccuracies because of what they pick up from popular TV programs. I've had people refer to the Fifth Amendment and the Seventh. Thankfully, never the Second Amendment in the Singapore context, but that's not entirely uncommon. And at the other end of the spectrum, I've had people talk about supremacy of Parliament and that kind of thing. Yeah, so we try to engage with them on this, but it is a challenge. I don't want to add to the burden of all of our students in Singapore by saying, oh, we've got to actually include some constitutional law, constitutional history in the school syllabus. I think that's just going to turn people off. But it is a challenge when there are so many things people get occupied with, and that they realize to try to send out a message about how our court system works, how our constitution works, and importantly, the proper division of responsibilities between the legislature, the executive, and the courts. Again, one of the other misconceptions by some segments of the population of people is that the courts kind of take instructions from parts of the executive or kind of that kind of thing. So we want to emphasize our independence. We want to send out the message, and we do that in our judgments, in many cases. But increasingly, I think that may not be entirely enough. People don't read judgments.
That's true.
The other thing we've been trying to do, and my corporate communications colleagues are also involved in the process of trying to summarize some of our important judgments. We involve students in that effort as well to make it comprehensible, make it short. But again, not everyone reads the judgments and not everyone reads the summaries, and then people pick things up from social media, they pick up snippets and that kind of thing. So it's a huge challenge trying to put out an accurate picture what is the correct position. And it is difficult also to do it with recognizing or giving weight to all the nuances, because the answer is rarely clear cut. I mean, we have to say it's a complicated thing. There's A, there's B, there's C. So I think it is a challenge. We've built up our corporate communications division quite extensively, and I think they're helping us to try to figure out how we engage with the wider population to help them understand why certain decisions were reached, what the usual practice of the courts might be. It is not an easy process to make it short, accurate, and entertaining at the same time, but I think they're trying their best, and they've been engaging with various content creators to try to do that. But it's an ongoing thing. I can tell you, it's something that's been plaguing a number of us, including the Chief Justice, over the years. We've had discussions about it. At one point, I was actually thinking, maybe we should try to create or work with someone to have a TV show about the life of a judge. Yeah. There were some good films about the challenges that a judge faces. For example, particularly in relation to sentencing criminal cases. I think that's one of the areas where people see there's a lot of controversy. Sometimes people see a lot of different issues cropping out. They don't quite understand why the judge calibrated it this way, why it's a fine, not a...
And then they make assumptions.
They make assumptions, and then sometimes they think we're colored by certain things, which is far from the case. And I thought, it might be a good idea, because there was that, there was the film The Children Act, which was a British film which showed the difficulties that a family judge face when dealing with custody issues. And I thought it might be good for this, but as I thought about it and discussed it with my colleagues, we realized actually no one really watches TV anymore.
But it could
it's a
make
YouTube
a good
video,
Netflix show.
Instagram, TikTok. I don't know whether we could do TikTok. Maybe we could do one of those short fiction, the short film things that seems to be the rage now. So I don't know, but that's the kind of thing. We're basically, I'm Gen X, but I don't know how to reach out to Gen Z or Gen Alpha. So we want to try to do that. So it's important for us to think about it. and to engage with the whole population. And although I'm speaking about Gen Z and Gen Alpha, we also need to make sure that we don't forget about those who are older, from the Merdeka generation, the boomers, who also need to engage with the process to help them understand. So it is a challenging situation. As you are doing the podcast, maybe we need to do more podcasts. We may need to figure out other content channels to reach some of the older members of society. And yeah, it's going to be something that will require a lot of the engagement and thinking.
Right. I mean, what you've mentioned, Justice Aidan, I guess is a good entry point into what I want to touch on next, which is AI and technology. In a Singapore Law Review lecture, The Obsolete Judge, you noted that contemporary societies, including Singapore society, they demonstrate a strong desire for personal autonomy. Now, do you think that changes or shifts the justice landscape in Singapore? And if so, how might technology help to or be harnessed to manage this changing situation?
Yeah. I think the attitude of people generally around the world to participating in the justice process and being involved in disputes is changing from what it may have been even 30, 40 years ago. And I think part of it is a greater distrust of authority across the board, coupled with, as you mentioned, a belief or inclination to rely on their own actions, their own autonomy to deal with things as far as possible. And it's also possibly coupled with some element of distrust of expertise, not just authority, but being wary of what people might say experts in quotation marks, including unfortunately lawyers and other professionals. So there is that driving force that I think pushes people to try to see whether they can actually navigate disputes on their own. And this is perhaps also seen a greater readiness of people to prepare their own wills, have their own contracts. And not just the ordinary layperson, but even like business owners. I can see that some of them are thinking, oh, can I do this on my own? This is not to downplay the other driving factors, including increased costs. That is another challenge. Legal professional costs, I think, are generally rising around the world. So faced with this, I think the our court system, and I think is something that the Chief Justice has asked us to focus on. We want to try to see what we can do to better prepare the court system, the judicial system, to deal with people who prefer to go through the court process on their own. So again, other aspects of the problem may be better dealt with by the executive and legislature, but this, in terms of facilitating participation, I think that's something that clearly lies within the ability of the courts to facilitate or pave the way for. And here, I think in particular, because we're often dealing with information, trying to make the information palatable, readily accessible, perhaps translated into other languages and that sort of thing, it is actually a prime area for us to consider deploying technology. So, for example, as I mentioned, the summarization abilities of Gen AI is pretty good. It also generally is pretty accurate, not 100%.
Not 100%,
but
correct.
pretty accurate, especially if you make sure that the reference materials, the source materials are there and there's proper cross-referencing. And hopefully people will be we will prompt people to check, but also hopefully people will get into the habit of checking the summarization. And then in terms of translation, I mentioned the translation of documents, materials seems to be pretty accurate by and large. And also then transcription of proceedings, not entirely there, but we're working at it. As an aside, what I can say is that my colleagues and I are working on that. My colleagues have been working on a number of projects to try to push this through, taking a lot of time. There's some continuing challenges because our court environment isn't quite the same thing as when you speak into a phone with one side. There's a lot of possible sources of noise and disruption, but we're trying to overcome that. But essentially, there are many things we could do harnessing technology to make the engagement in the justice process easier for everyone, and that's something we really want to do. And Gen AI can play a big role in that. But what I must emphasize again is that we're not married to Gen AI.
Sure.
Even as we use technology, sometimes other forms of AI, machine learning might be useful. Sometimes even algorithms or rules-based processes might be appropriate, as you can see with our motor accident outcome simulator, which helps people understand the likely outcomes when they're involved in motor accidents, the percentage of blame. And we're actually thinking of exploring, or my colleagues in the family justice courts are thinking of or looking into deploying similar processes to deal with maintenance disputes, where there are many criteria that can be fed into a system which will help indicate a likely maintenance figure in various situations. So we're exploring all this, and we hope through all of this we can, as I said, make the experience a bit better, help people reach an outcome that is satisfying, but basically make sure that they feel that they are able to participate and that they have had a fair go. What I must emphasize is that we're not trying to make everyone happy. No court process can make everyone happy most of the time. Occasionally it can happen, but it's very, very rare. At least one person will probably leave the court process unhappy if the ruling is against them.
Right.
Sometimes both persons. But we want to make sure at least they feel it was a fair process, that they don't feel that they've been badly affected by something arbitrary. They may disagree with the outcome reached by the judge, they can appeal the process, but they don't feel that the system as a whole is against them.
I mean, what I can gather just from your explanation is something that I can relate to in teaching and learning as well. We want to try and harness AI in teaching. There are challenges, of course, and one of which is about fairness, right? Ensuring that there is a level playing field for everyone, which I think AI could be a hindrance to that in some ways, Mario.
Yeah, I just want to push you a little bit more on this idea of fairness. Correct. While you harness all this great potential and promise of Gen AI, finally you want a fair outcome and you want justice to be delivered. There are risks, for example, like fake authorities being cited and so on. So how do you sort of balance this, the potential of Gen AI with coming up with a fair outcome?
Yes, so it is important to us, and we want to make sure that we identify the risks, we minimize the bad outcomes. So in terms of the users of the court system, leaving aside the use of systems which are provided or facilitated by us, when people come to court, according to our guidelines or direct practice directions, people have to own what they use. And they need to be aware that if they turn to Gen AI for whatever they produce, they are responsible for the outcome. We've tried to emphasize that. And when we do identify these issues cropping up, consequences will follow. But aside from that, when something is presented to a judge, the judge shouldn't be taking anything at face value. They should be looking at the arguments, and they should also be checking on it, looking at the cases that are cited, for example, reading the relevant passages. So by and large, we think this would be able to catch a significant proportion of the cases. And also on top of that, given that we're in an adversarial system, the opposing counsel will also presumably be looking at everything and reading the claimants' cases to make sure that they have some response to it, and in doing so they'll be able to catch those that are fictional or perhaps exaggerated. So there are these mechanisms within the current system to catch it, but at the same time, we're aware there might be other kinds of hallucination or fakery that may not be caught by these things or harder to catch, and we're trying to work out what we need to provide to the judge to make his or her life a little bit easier in trying to keep tabs on these things, including where appropriate systems to try to run through citations to match them against what we have and that kind of thing. So it's an ongoing process, but ultimately the key safeguard is really the expertise of the judge, and we want to make sure that we train our judges to be alert, to take their responsibilities seriously, and that we make sure that they themselves never feel that they should cut corners and basically abandon everything to an AI, that we want them to exercise that human judgment, which is actually the core of their role. So we're developing internal guidelines and reminders for judges, and where appropriate, we will also roll out training to help them identify and spot these issues. So I'm working with my colleagues to try to map out what needs to be done. And importantly for us, we want to make sure that even for the AI systems that we implement within the courts, whatever we do to harness the AI models that are available to us, we have a constant checking of accuracy and reliability, and we're trying to work out the mechanisms for that.
Mm-hmm. Now, you mentioned something very interesting as well, and I think this is the big question that people are wondering. Just as something related to that, I've been told that now even podcasts can be generated by AI hosts.
Yes.
So maybe we'll be out of jobs in the future.
I must say that what we saw online with Notebook LM, it was very, very good. And we were actually thinking of harnessing it to publicize some of our cases. And we were also very, I think, attracted by some of the latest developments, because you could actually have slide decks generated with graphic descriptions. And we've tried it with some of our more complex areas, and we're very pleased with the outcome.
Wow.
So it's something that I think is very useful. But I think for the time being, where these perhaps are a bit lacking is in terms of immediacy to the intended audience, because AI as it is, there's a skew towards American accents, for example, American concepts. And I think, no doubt, some people will be working towards a localization for these things, but I think that does show where there is a lot of room for humans to be involved in the process, to actually take the additional step of just taking the output, making sure it's correct and that sort of thing and accurate, but also then honing it, refining it, and making it that much more relevant to a specific audience. So whether it's the students or let's say Singaporean audience attuned to Singaporean idioms and that kind of thing.
I guess AI podcast host is not too much of an issue, but an AI judge could be, I think, a bit of a serious issue, because the role of the judge, I think, is tied to public trust in the justice system and all the qualities that a human judge brings to the table. So what do you think about that?
I think so. I think we're quite far off from people being comfortable with AI judges. I can't say that it will never be the case, but I think certainly for this generation, our current generation, as well as possibly our children or perhaps our children's children, I think there will still be a need, again, a visceral kind of human need to know that when an outcome is in doubt and it must be weighed and considered, the ultimate call is made by a human being. Because the role of the judge is not just to arrive at a particular legal or evidential decision. It's also about the judge actually weighing human factors in it, whether it's in criminal case, family law case, or commercial dispute. People will want the determination to be done by a human being who understands the human condition,
Correct.
who understands human motivation and the kind of probabilities or likelihood of certain human actions and that sort of thing. So I think that will still be at the core of the judging process for at least a couple more generations. Beyond that, perhaps we'll come to a point where our children's children may be comfortable with AI decisions, but
Because
but then
I agree with you, because from the way I see it, I suppose the role of the judge is not mechanical, whereas AI tends to have that mechanical, technical vibe or feeling about it.
yeah, I mean, we may get the point where AI can fake a human judge's thinking, but I mean, I again, I don't know that comfort level will rise for many generations.
Before we conclude, I'm just wondering whether you can reflect a little bit on the future.
Right.
What should legal education, for example, be doing about Gen AI? How should we be preparing the next generation for Gen AI? What should the academy, the Singapore Academy, the Law Society, be doing about this? And what are some of your reflections on the future?
Yeah. So the Chief Justice and some of my colleagues have been looking at the issue together with some of our stakeholders, and there was a report not too long ago, I think making certain recommendations and preparing our law students for the future. And it goes beyond technology and AI, but just really the general environment that has to be prepared for. But turning specifically to technology and AI, I think one of the things that is worrisome, and this is something that is shared by the Chief Justice and many of my colleagues, is that because Gen AI seems to hold great potential, it's actually already displacing a lot of the basic level grunt work that is normally given to young lawyers to help train them. It's going to require us to think about what can be put in to substitute for the loss of such work. Now, there are things that we really don't have to bother about, like, for example, perhaps creating slides or on a mechanical level, compiling bundles and that kind of thing. We don't have to worry about that. But it's really a question of judgment, basic legal research, trying to figure out what's the best way of phrasing a research query, trying to trawl through and decide which bits are relevant, learning, for example, to do targeted reading, accurate targeted reading, everyone can do targeted reading, but being accurate in your skimming and scanning and learning how to zoom in on the relevant parts.
Right.
All those are techniques and expertise that require practice, and we're losing all of that for the younger lawyers. And the other important part is that because AI is able to generate things easily, you need to have a skeptical frame of mind to judge the output, and you also need to know what an ideal output looks like.
Right.
So if we lose all this basic groundwork, we don't have that training pathway. What do we do to replace it? So I don't have an answer. My colleagues and some of my colleagues have been thinking of various things, using AI to substitute it, perhaps creating situations, creating problem sets that somehow challenge them on this basic work. So even though we take away the work with one hand, we give it back to them on the other. That might work. We may need to relook at some of the training that's done, even let's say in university, and that we may need to incorporate some further forms of, some of your colleagues may not like it, vocational training at the undergrad level. That sort of thing. We may need to have more role play, and we may need to boost up our continuing legal education. So some of these aspects have already been looked at by the universities, I'm sure, and certainly by the Academy of Law. But it's the kind of thing that we really have to keep coming back to. And throughout all this, we have to make sure that we validate what we're trying to do, or we need to engage with the young lawyers involved to make sure that they feel that they are picking up the skills and that they can deploy these skills in a real world setting.
Fantastic. Justice Aidan, thank you so much for your time. That's about all the time that we have, but this has been a fascinating conversation. We could do days on this, really, but we hope to welcome you again to another episode of CALS Chai Chats
Well, thank you.
in the future. Thank you for your participation.
Thank you for having me.